SJC-12111, City of Revere and others v. Massachusetts Gaming Commission and others, and SJC-12177, City of Revere and others versus Massachusetts Gaming Commission and others.
Good morning, Your Honors.
Wait, hold.
Now, good morning.
Now, good morning, Your Honors. May it please the Court. Kenneth Leonetti from Mohegan Sun, Massachusetts, LLC. With me is Michael Hoven. In the very first sentence of the Expanded Gaming Act, the legislature states that ensuring public confidence in the integrity of the gaming licensing process is the paramount purpose of the act, not the creation of jobs, not economic development, not tax revenue, but ensuring public confidence in the integrity of the licensing process. Despite this, the Massachusetts Gaming Commission has taken the position that the most important decision it will ever have to make is beyond review by this court or any court under any provision of law.
So you get certiorari review under the judge's decision. Is that adequate?
Yes, certiorari is adequate, Justice Lang.
And
So-
what,
But you're not pursuing the 30A.
We are pursuing,
What difference does it make whether you're under 30A or under certiorari review?
I think that, Justice Lang, I think 30A does provide a few more remedies in terms of what degree of investigation the Superior Court can make, and I think it would be more proper for the Superior Court to undertake 30A review, but we are content with certiorari review nonetheless.
what would that review look like from your perspective?
Well, so the review is, in the initial instance, you're entitled to the administrative record. We've contended, this issue has not yet been adjudicated before the Superior Court, but we have contended that we also need to have some materials beyond the administrative record, which is in internal emails and other communications at the agency. And I think that's because one of the core aspects of our case is that there were secret meetings and there were ex
Are you pursuing the
parte.
open meeting law stuff?
That's not your claim, is
That's
it?
not your claim. Those are the individuals'
No,
claims.
our claim, you're correct. Our claim is not the open meeting law claim. Nonetheless, we contend that this process itself contained secret meetings in which certain decisions were negotiated outside of the public view. Notwithstanding the fact that that's not an open meeting law claim per se, Justice Lang, it still goes to the arbitrary and capricious nature of the Commission's decision.
So you want discovery in a certiorari action?
Very limited, and that's
But why do you get any?
discretionary.
Yeah, when
Why
do
do
we,
you get
when do
any?
we ever allow discovery in a certiorari action?
It's up to the discretion. Well, certainly our issue is that's why we need 30A, because we should be allowed very, very limited discovery. I'm not asking, we haven't, and this is not before this court at this moment.
Well, I understand, but the issue, if you're going to get review, it matters what it looks like. So I think it is sort of before us.
So, well, it certainly is up to the discretion of the Superior Court. And the Superior Court, at least in the first instance, said she was not going to allow discovery, but she would wait and see where the administrative record took her. But I would like to talk about the certiorari claim in particular, because that's what we are here on the Commission's appeal. They've taken the position that the certiorari claim is not legitimate because Mohegan Sun does not have a justiciable right.
Well, okay, and they say because really what you're doing is challenging the fact that you didn't get the license. I must, and you say, oh, no, we don't. This is because we're wonderful citizens and we want the process to have a lot of integrity. I mean, isn't there something to the fact that you're there because you didn't get the license?
Of course, Justice Botsford. That's exactly why we're there. But that's true in probably the vast majority of the administrative appeals that are brought by any party. It's always the disappointed applicant who has the economic interest.
So what's the outcome of your 30A if you don't have a right to get the license once you've been denied? What's the point?
Here's the point, Your Honor. The outcome of our 30A is a reversal of the decision granting the license to win. That is the entirety of the outcome. And that's why, despite what they say, the Commission says, we are not challenging the decision denying Mohegan license. And that's the only thing that 17G says.
But if you can only give one license, and that's the point here, giving one means somebody else doesn't get it.
Yes, but giving one doesn't mean that necessarily that the disappointed applicant gets it. And that's, I think, what's
So-
critical.
So you're saying that no one should get it, and that would be the,
That's not up to us, and that's not up to the Superior Court. The only relief we were asking the Superior Court to enter is to enter an order vacating the award of the license to win. We're then back at square one.
So
And
what's, so if you don't have a right to the license, how is it that awarding the license to win is a problem for you?
Because
What's your interest in it? What's your standing to complain about that?
Because we're then going to go back to square one, and hopefully the commission is then going to have an open and a fair process, a process that does not result in the award of the license, in our view, in contravention of a number of elements of the statute, and a license that is not a result of predetermined discussions.
Well, then, doesn't that just mean that the grant of a license is the same as the denial of an application of a license in this context?
No, because the commission did not have to award us a license, Justice Lowy. The commission could, and in fact, again, if it goes back to the Superior Court and the Superior Court vacates the license, we're back at square one.
Yeah, I'm trying to figure out what certiorari review would look like when much of what the commission looks at are matters of public policy. And the judge, I suppose, would look to see whether or not the decision was arbitrary and capricious, but we're talking about economic benefits, et cetera. How is that properly something the judge can decide?
We are not asking the Superior Court to consider the weighing factors, the economic policies. What we're saying is that there was, for instance, it's our contention, and we're here on a motion to dismiss, so it's our contention that there were individuals who had criminal ties who benefited from the ownership and transfer of the Everett land. The statute says expressly that individuals with criminal ties are not supposed to be benefited. So that is a facial statutory violation. It's also our contention that there were ex parte communications with Wynn. That, in our view, is arbitrary, capricious, and a violation of the statute.
But all of these things that you talk about are necessarily outside the record.
Well, I think the issue of the criminal elements is within the record. I think that we can be established within the
So
record.
why did you not bring an action under Chapter 268A, Section 9A, seeking rescission because of violations of 268A, Sections 2 through 8, or Section 23?
Because at the time, I mean, we were challenging the final administrative agency decision, and so certiorari and 30A, in our view, was the only proper.
So you're saying you're claiming it's arbitrary and capricious only because of the procedure and not because of the analysis?
Yes.
And is that some variation of certiorari review, which you say is dictated by the limitations in 17G, or is that simply because that happens to be your argument and others who come after you could make the argument that it was arbitrary and capricious because it was not in keeping with public policy?
Well, it's our position that what was 17G doesn't apply to bar certiorari review. Certiorari review is independent of 17G. 17G,
So you're saying that 17G, once you get to certiorari review, 17G has no consequence even in terms of our view as to what the scope is of that review?
yes.
So that would mean, well, am I right, that what you're saying is you say you're not doing it in this case, but it would be perfectly legitimate for a disappointed applicant to seek certiorari review of the fact that the commission had not granted that applicant the license?
No, I don't think you can get certiorari review for a grant. I think you can only get certiorari review for a denial, even though 17G doesn't apply. And that's because I think that
Well, that's what I'm saying. I thought that's what I mean, if you were denied the license, you could challenge it through certiorari even with 17G?
No, I just don't think 17G has any place in the analysis of the certiorari. 17G is solely because the only place 17G has a place is in the 30A analysis. That being said, a disappointed applicant would not have certiorari review because they have no justiciable rights. That falls squarely within the one case in which this court has held, of all the cases cited, the 24 or so by any party in which certiorari review is considered by this court. The only case in which certiorari review is denied because there's not a justiciable right is INDEC. Right? INDEC, I think, if you were challenging the denial, I think that's where it falls within INDEC, which is you're challenging something which you have no right to receive.
So if Wynn had been denied, and Wynn says That's because of all these contacts they had, these corrupt contacts, and because a process which was wholly unworthy of this Commonwealth. They could not challenge their denial pursuant to certiorari, but you can.
I could challenge the denial if I really wanted Wynn to get the license.
You can challenge
No,
the
no one
fact
can
that Wynn
challenge
got the license.
No one can challenge the denial. The only thing you can challenge is the grant.
And the reasoning of that is
Under
because...
in the
you're
certiorari, because
saying
no one
it's-
has a right because that's what index says. You have no right in the license. So therefore, if you have no right in the
Sir,
license,
you're right. I mean, if there was only one applicant who was denied, you only have a right because there were two applicants, is that right?
yeah, we only have a right to challenge a grant. It's irrelevant whether there's one applicant, two applicants, or 10 applicants. The only thing you can challenge is the grant of a license. You can't challenge the denial under certiorari, and that's because no one has a right to a license.
And that's what I'm trying to understand, what your legal interest is in the granting of the license. I mean, how are you different from anybody else out there?
Because we were an applicant, and so we suffered a justiciable, we have a justiciable right because we suffered a substantial injury and a substantial injustice, which is the test.
If you were unfit, if you want the license, right?
That-
Because you're
that's right.
denied the license.
That's right.
But you go back to that which is not supposed to be justiciable, which is the denial of your right to the license.
But-
It's circular.
No, but the relief we're asking for will never result in our getting the license. That I think, Justice Hines, is the critical distinction, which is the relief we are asking for, we are not asking that we get the license. At the end of the day, if we win this case, nothing will result in our getting the license. We're back to square one. The commission can do a whole host of things that it wants at that point. Yes, it could decide to award us the license. I doubt it will. It could say we're going to open up the process again to everyone. All the applicants come in and let's do this again. It could say, you know something, let's wait and see how gaming is going in Springfield before deciding to go forward. Or it could decide, you know something, we're going to have a redo between Mohegan and Wynn, and we're going to each have them do it. We're going to go through this process one more time. And that's the critical distinction, is that nothing we are doing is asking us is asking for the reinstatement of the license, and that's
You're
what
not here as an applicant, so Caesar's, the First Circuit case where Justice Souter sat by designation, has no application in your view.
Absolutely not. It does not, Justice Lowy, because in Caesar's, the applicant was challenging its denial. In fact, that was his whole complaint, was that it should have, the way it was treated in the process as an applicant and the denial, that's where it claimed it had a constitutional due process violation, because it was deprived of its right to get the license.
But what do you say, since the statute has a whole, defines a whole process of applying, and I completely understand there is no property right in a license. However, you would say that for somebody who's been denied, let's assume that the commission is completely corrupt, everybody's on the take. No relief because it's just a denial? That would be okay?
Well, I guess you could bring an action to the State Ethics Commission at that point, which could undo it. Yeah, but you're right. There may be a circumstance where it's so extreme that someone can challenge it. Someone could challenge a denial. But even then, I think the point is that the way the legislature set it up, which is the status quo at the time of the Expanded Gaming Act was enacted, there was no expanded gaming wasn't allowed. So the legislature says we're going to allow expanded gaming, but we're going to have very, very specific criteria. So in other words, the default is there's no gaming, and if you satisfy all of these criteria, and if the commission is satisfied that all the 16 mandatory criteria and all of the 18 permissive are satisfied, then we're going to have gaming. And that's why there has to be judicial review, because having set up this serious process with a lot of different elements, and having said that ensuring the public confidence in the integrity of the licensing process is what's vital, you cannot then say that under certiorari or under any provision of law, the commission can then say, okay, fine, we're going to award this license in derogation of the statutory.
What if the legislature had said there should be no review, including no certiorari review?
I think that would be an unconstitutional delegation
So to the extent then that the legislature says, we've got all these folks with a lot of money to pay a lot of lawyers, and the Gaming Commission, we're going to set up strict criteria for its decision, and what we don't want is we don't want the loser, and you are the loser.
No doubt.
To be able to hang this up in the courts for 3 to 5 years with an extraordinarily challenging decision for any Superior Court judge to do, which will then, of course, be appealed. We don't want this hanging around in the courts for 3 to 5 years. You're saying there's nothing they can do to prevent that?
No. And here,
I'm sorry, no, there's nothing they can do to prevent it, or
Nothing
no,
there's-
I'm not right?
No, there's nothing. Yes, you're right. And there's nothing they can do to prevent it. And that's because the legislature has enacted a policy. We all agree this is a policy decision to allow expanded gaming. And under the second prong of the separation of power, the delegation test, they've certainly satisfied that, which is clear guidelines for the implementation. But having done that, there has to be adequate means to ensure that the delegation and the legislative policy is followed. And the clear means are judicial review. The political controls they point to will not ameliorate the harm. And that's what makes this case very different than the Powers case.
You say there's nothing within the statute that provides safeguards against the abuse of discretion. You've got number of commissioners, you've got all these regulations that address it, and that nonetheless judicial review is the only way to safeguard abuse of discretion.
Yes, for the grant, given the fact that because in this case, what we've alleged is violation of the statutory requirements. So in that case, the fact that the commission, the 3 of the 4 commissioners who voted went along with the violation of the statutory requirements, and the fact that even the commissioners are removable for cause, that's not going to ameliorate the harm either, because the license has already been awarded.
Okay, thank you.
Thank you.
Ms. Davidson, good morning.
Good morning. Patricia Davidson with James Cipoletti and Paul Capizzi on behalf of the City of Revere. Revere must have standing because it is grieved under Chapter 30A and has suffered substantial injury or injustice under the certiorari statute because it has incurred legislatively and contractually mandated losses
So
of
you're
economic
saying
benefits.
that Revere has a right to proceed for cert review or for 30A review?
For both.
For both.
It is both aggrieved and has suffered substantial injury under the certiorari statute. Both the legislature and the commission, under the act, required that Revere be an integral part of the licensing process
But
every step
it's
of the
for
way.
mitigation, isn't that the purpose of those agreements? It's mitigation of the effects of having, in this case, Mohegan Sun come into your hood?
In part, but both the Superior Court and the Commission de-emphasized improperly that a paramount objective of the Act is not only the mitigation, but the promotion of economic benefits. And the City of Revere,
But but you don't find it strange that Mohegan Sun has no right to challenge the denial of the license, but you have a right to challenge the denial of the license?
well, I believe that Mohegan certainly does, and as the Superior Court agreed, that through the certiorari statute, it had the right to challenge, and I would agree that it has the right under 30A as well. And certainly looking at the certiorari statute, which provides a broad remedy, it provides the type of judicial review that prevents the abuses of discretion that are allocated in the complaint. And because of the host community agreement, there were contractual benefits that Revere was supposed to obtain. And when Mohegan Sun was not awarded the license, and those losses are the type of direct and ascertainable harm that this court talked about in the Boston Edison versus the Boston Redevelopment Authority case, which should provide the standing that is essential in a situation like this.
What do you say is the scope of the certiorari review?
The scope of the review is limited to the record, and certainly 30A would provide, under limited circumstances, some discovery that my colleague discussed.
But for certiorari, what about that? What's the scope of review under certiorari as opposed to 30A?
Well, it provides the judicial review of the record for the abuse of discretion
So,
that
so
we're talking about
you
here.
want a Superior Court judge to be reviewing the overall wisdom of the decision and determining whether or not there was an abuse of discretion?
Yes, of course. That's paramount here. There's no question that gaming is controversial, and as a result, the ARC has these overarching concerns for the public interest, and it's drafted to ensure public confidence in the system. When the Gaming Commission breached that confidence by engaging in behavior that's delineated in the complaint, it is paramount that the parties have a right to judicial review, and the public depends on that judicial
Why wouldn't they
review to
get
preserve
it?
the integrity of the act.
Why wouldn't they get that if Mohegan Sun can pursue cert review? Why do they need the city of Revere to also get it?
Well, the city is not a shell for Mohegan Sun. The city has its own interests, namely the promotion of economic opportunity, the jobs that it would create, the
Well, there's
economic
no
benefits.
doubt that the city of Revere is aggrieved by what happened. You've got taxes that could help the schools, maybe do something with the mess in the vacant area around Wonderland Dog Track. All of
Absolutely.
that, and that's obvious. But nonetheless, the statute says there's no legal right or privilege to a license. So the fact that Revere was hurt doesn't mean that you're aggrieved within the statute.
The statute does not preclude a host community from a right of appeal. It just does not say that. The plain language of the statute does not say that. And again, we're not challenging the denial of the license, we're challenging the award
So
of the
Brockton
license.
has a right as well? Every other aggrieved host city has a right to review.
Well, Revere is specially situated because we have the host community agreement that is mandated by the act and enforced by the commission. The commission required that the city of Revere be part of the process every step of the way. We had 2 referendum on the issue. We gave testimony, we responded to inquiries. We were at the table every step of the way. So for the commission to argue that we are somehow not aggrieved or haven't suffered substantial injury is incongruous
I don't
because
think
the
they're
act
saying you haven't-
required the
I don't
city to
think
be.
they're saying you haven't suffered injury, but the question is whether it's within the scope of the statute.
Exactly.
And it certainly is, because
How?
this, because
How?
this,
I don't understand that.
because by virtue of the host community agreement, the city was mandated
Well,
by the
let's-
act
the
to enter
question,
into this contract.
Why was the host community provision in the statute there? I mean, what was it intended to do?
Both mitigation, but also to promote economic benefits. And that is the key distinction here. And the Superior Court didn't notice that. It only focused on the mitigation aspect of the act, but not the affirmative obligation to promote all of these public interests. And that's what gives the city standing in this situation.
All right, thank you.
Thank you.
Mr. Hart, good morning.
Thank you, Mr. Chief Justice, and may it please the court. My name is Chris Hart, and I'm arguing on behalf of IBEW and the 4 individuals. I'll be focusing my argument on the individual's open meeting law claim. The open meeting law claim presented by the individual centers on the same key issues that we've heard today and that underlie Mohegan and Revere's arguments, and that is simply the fundamental integrity of the gaming license process. The purpose of the open meeting law is to ensure transparency in government. And the individual's central claim is that the Gaming Commission repeatedly, throughout the Region A licensing process, failed to adhere to the law's standards of transparency, detrimentally affecting the fundamental character of the licensing process and thus of the ultimate grant of the license.
What the judge said was basically that you hadn't met the Giannichino standard because the allegations are sort of based on leaps of, unfounded assumptions. If X is true, then Y must be true as well. And what do you say to that?
What I say is that the Superior Court got the standard wrong.
Got the standard wrong?
I'm sorry. The standard is correct, and that is the Giannichino standard is this, as you know, Justice Botsford, that the factual allegations that must be pled must rise above the level of mere speculation. What the Superior Court got wrong was saying that the allegations in the complaint, as well as the calendar entries for which it took judicial notice, did not rise above the level of speculation. That's what the Superior Court got wrong. Essentially, what the Superior Court stated was that the allegations were merely conclusory. In fact, there are 15 paragraphs in the complaint that state that what the open meeting law claim consists of, including 3 specific examples, and I'll recount one for the court, and that is toward the end of the licensing process, 2 days before the final vote was to be given with regard to the award of the gaming license, there was a colloquy between the commissioners, or among the commissioners, regarding conditions that had been provided to the applicants, and for which there was some concern that Wynn's failure to abide by, or at least to state that it would be complying with those conditions, put that, as the commissioner suggested, put that application in jeopardy. The commission then recessed for half an hour, and came back and provided the applicants the opportunity to, quote, clarify the response to those conditions. This was an ad hoc new procedure that had not been provided before to the applicants when the commission had outlined what the procedures would be in August, just the month prior. I think based on those facts as alleged, Justice Botsford, those allow for a permissible and reasonable inference to be drawn that rises above the level of speculation. So in addition, however...
So your view is that if any commissioner speaks with another commissioner with regard to anything going on concerning this decision, it has to be done in an open meeting?
No, what the open meeting law states is that if there is a quorum of the public body that deliberates over public business, then that must be done in an open meeting.
Okay, so you'd have to infer that this discussion, which you say occurred during those 30 minutes, occurred with a quorum.
Well, at that point, one of the commissioners had already recused himself, and so there were 4 commissioners there and 4 commissioners recessed. So yes, the inference to be drawn is that all 4 commissioners, or at least a quorum of those commissioners.
And recesses were a normal thing, though.
That's true. The recesses were normal. However, again, the issue here is what reasonable inference can be drawn given the circumstances that are alleged in the complaint. And the reasonable inference under the motion to dismiss standard, given both the complaint of Wynn's reaction to the conditions, as well as the new provision that was provided after that recess, lead to a reasonable inference there was some deliberative meeting that happened behind closed doors.
Okay,
Thank you very much.
Mr. Mackey, good morning. You're outnumbered.
Good morning, Your Honors. No, we're not outnumbered. Have here with me my
Oh,
colleague,
you evened it out.
Melissa
Okay, good.
Allison,
There you
Mr.
go.
Macarios.
Okay,
We
good. That's
represent
fair. That's fair.
the Gaming Commission this morning, and as we're going to argue, we have the law on our side, which is the great leveler. With the court's permission, I intend to proceed through the claims in this fashion. First, to focus on Mohegan's intervener's claims, including his claim for judicial review under Chapter 30A, then his claim for judicial review of the licensing decision under the certiorari statute,
Well,
and then
could you focus mostly on the certiorari, since I think they are?
Will do, Your Honor. And then lastly, with respect to the judicial review claims, the non-delegation doctrine claim, and if time permits, I'll then proceed to address the claims by Revere and IBEW and the open meeting law claim. The last sentence, Your Honors, of General Law Chapter 23K, Section 17G, is the key source of law with respect to the claims for judicial review. That sentence provides that applicants shall have no legal right or privilege to a gaming license, and it further provides that applicants shall not be entitled to any further review if denied by the Commission.
Mr. Mackey, if the allegation were, with some basis, it wasn't just made up out of whole cloth, that in fact, it's what I asked your brother, in fact, the commission was completely corrupt, that this whole decision was, based on bribery, whatever, and there was some factual basis for that. Out of luck completely?
The key presumption in that question, Your Honor, is there some factual basis for it?
Well,
First,
but your argument seems to be under no circumstances is there any review, and I'm just trying to see if there is under any,
That-
in your view.
That's not our argument, Your Honor. We have heard from the plaintiffs throughout this litigation that, the sky is falling, the commission can act in an utterly lawless manner without regard to, as Mr. Leonetti just said, any of the laws in the Commonwealth. There are several provisions in the Gaming Act itself that provide for judicial review. There are a number of political safeguards in place, which we've described in our briefs, which constrain the commission at every point. But I'd also like to add here, Your Honors, is not just the sections of the Gaming Act where there were subject to judicial review or these political safeguards that I've mentioned. There was a very energetic attempt by the city of Boston here to annul the Region A gaming license. That attempt asserted dozens of violations of the Gaming Act, including violations of the Gaming Act under the Conflict of Interest Law, Chapter 268A, as well as violations of the Gaming Act related to who was the host community, who was the surrounding community, et cetera. Now, we resisted many claims in that litigation based on lack of standing and based on there was no judicial review. But I will say, the Superior Court determined de novo and on the merits that the Gaming Commission rejected Boston's claims and determined that the Gaming Commission had correctly identified the host community as the city of Everett, had correctly de-designated Boston's surrounding community status. Beyond that, with respect to a laundry list of Chapter 268A claims, which the city brought to try to annul the license, again, on the merits, the Superior Court judge found the claims lacked any factual basis, they lacked any legal basis, and in fact were utterly spurious. So we do not contend that there's no review whatsoever here, but we do contend there is no review of this discretionary licensing decision
Okay, so
and the
there's
merits.
there's no right to an award of the license, but why isn't there a right to judicial review to challenge the process, to make sure that it satisfies procedural due process in the manner in which the commission decides to award the license?
In our view, Justice Lowy, both this court's decision in the Abdow case and Justice Souter's decision in the Caesars case foreclose that. Under Section 17G, there is no right to a gaming license, and I should say that in our view means no constitutional right, no contractual right,
But given
no
in
property right,
that's a
no
given in my
justiciable.
question. That's a given in my question. My question is there a right to challenge the process?
In our view, there is absolutely not a right to challenge the process here, because both the Abdow decision and the Caesars decision, Chief Justice Gantz and Abdow talked about, a challenge to the process leading to the license and having a right in that process where there was no right whatsoever in the license itself as a departure from common sense. Chief Justice Souter, sitting by designation in Caesars, went on at length about this notion that Caesars had brought that there was some free-floating right to due process without any right to the outcome of that process, and he rejected that claim.
Okay, so you're still stuck with Justice Botsford's question, which is, well, I guess I'll reframe. Delegation, the first legislative findings, very first, ensuring public confidence in the integrity of the gaming licensing process through a rigorous regulatory scheme is the paramount policy objective of this chapter. What do we do in a world in which we have a gaming commission, which I'm not suggesting is what we have now, but let's imagine a world in which the Gaming Commission says, yeah, I know they established this regulatory scheme, but we don't need to follow it. And there's a lot of money here, and we can be on the take. And if we ignore the statutes and the regulations and we make some money on the side, nobody has the ability to challenge us, and nothing can undo our grant of a license. What do we do? Is the answer is that's just too darn bad? The legislature undid their first legislative finding by enacting 17G by saying nobody gets to challenge it.
Your Honor, no, that's not the
Okay,
commission's
well then
position.
tell me what the process is where, if we have that world, tell me where there is judicial review.
okay, putting aside the political safeguards,
Put
including
aside, what's the
legislative
political
revocation
safeguards
of
may not
license.
be able to
With
undo the
respect
grant
to
of a
judicial
license, can they?
review-
I'm sorry, the political safeguards you can fire the members. Does the political safeguards provide for the undoing of a grant of a license?
Absolutely. Here they do, Your Honor. We've seen an attempt through the initiative petition to do that. You've also recognized in the Abdow case that the legislature could, in one fell swoop.
Okay, so the legislature
take
could
away-
basically say, we're just not going to have gambling anymore, or we're not going to have gambling in the Boston area anymore.
That's
Okay,
correct.
apart from that,
Put those to one side.
So with respect to judicial review, and again, I would first again remind the court that there was extended judicial review of multiple aspects of this licensing process in the Boston case, which the judge rejected those claims. There was extensive MEPA review of the licensing process, which ripened into litigation that was then dismissed. Now, a number of courts on the federal side, we cited cases in our brief, the recent Quozo decision, which related to the Patent Office, the Bozeroff decision, and then Hahn versus Gottlieb, which is the First Circuit case. And in all three of those cases, they have something in common, which is no judicial review of the decision at issue. But in each of those cases, the court did address this. You know, what happens if the administrative agency just goes, you know, completely off the rails and does something that's utterly lawless? And the three cases deal with an interesting way. Quozo in the Supreme Court says, you know, we're not going to reach the issue here about whether the agency engages in some, you know, crazy shenanigans, because we don't need to. If there's a plain violation of the Constitution, we're not going to need to reach. We don't reach here the issue about whether or not we're going to need to step in. The Bozeroff case does the same thing. This is a case about the issuance of licenses for goods to export to foreign countries. No judicial review of that decision. But again, the Ninth Circuit was very careful to say, don't think for a second that we won't step in if they start doing something utterly lawless, like denying licenses to every member of a particular minority group. And then Hahn versus Gottlieb, which is a 1971 case relating to rent increases instituted by the Fair Housing Administration. We think applicable here for a number of reasons. But in that case, the same thing. The court says no judicial review of those decisions, but don't think for a minute that we wouldn't step in if there was some plain violation of the Constitution.
but they say there is a plain violation. That's their allegation.
Well, they say that.
May not
Yes, they
say,
that
you
in
may
argument.
not credit it, but I mean, you still haven't helped me to figure out, they say, they may be wrong, and perhaps they haven't particularized it sufficiently, but they say there's a plain violation of the statutes and the regs here. They say this group has run wild, run free, and that they say we need judicial review in order to prevent them from running wild or running free, and I'm asking you if they are indeed running wild and running free, what power does a court have to constrain that?
Well, first of all, I understand they say we're running wild and running free, but a careful read of the complaint, and in particular, I urge the court to look at it on page 12 of Mohegan's brief in 12177, the second set of briefing. You know, Mohegan will crystallize the 6 things that it says are the most outrageous things that the commission did throughout this process. And I won't go through them all, but I urge the court to look at them.
Okay.
2 of
And
those 6.
let's put aside whether their allegations are sufficient. Let's imagine that they would be required to particularize it if this thing goes forward, but imagine they did. Imagine they actually have said that they've made allegations that they have run wild, run free.
And those allegations are plausible.
Well, let's take the allegation as an example that they make about, benefiting people with criminal records.
It's just not a correct reading of the statute, Your Honor. Under Section 2 of the Gaming Act, the individuals, Mr. Lightbody et al., who were members of a realty trust that owned the property that was ultimately sold to Wynn, were neither, the statutory words are qualifiers, they were not, I'm sorry, close associates or affiliates of Wynn under Section 2 of the Gaming Act. Therefore, under Section 14A2 of the Gaming Act, there was no statutory duty on the part of the Gaming Commission to investigate the suitability of individuals who happened to own the land that Wynn ultimately bought to put the casino on. Now, there is a regulatory provision that says the commission has the sole discretion in terms of whether or not to conduct a suitability analysis of people who are not close affiliates or associates. The commission exercised its discretion not to do so here. Now,
So is your point, in answer to Chief Justice Gans, it depends on what is alleged, and what is alleged here in the Mohegan Sun complaint would never get us to where the three cases that you've cited to might look at?
that is correct. That is exactly right. It's all about the allegations in the complaint.
Mr. Mackey, early on, you said there were provisions for judicial review in the statute. What are they?
Regarding judicial review, sections 35, 36, and 45, I believe.
And what do they speak
It's
to?
about people who are fired and other things like that.
Yes, relates to ability to appeal from a revocation of a license once granted, an ability to appeal from a decision that you're excluded from the casino in some way
An
you've
individual.
acted badly or criminally and that you don't are not allowed to go into the casino. And there is a third one as well, and I'm not recalling the specifics. I believe it's sections 35, 36, and 45 of the act.
But none would have any application to this type of a claim,
Not in this case, no.
okay?
But,
So, all right,
again,
I'm still waiting to hear, to be satisfied that if this horrendous world that I describe indeed exists, that the courts can't just shrug their shoulders and say, too darn bad.
But I think, Chief Justice Gans, we're acknowledging if this horrendous world were alleged in a plausible fashion, unlike the way it was alleged in the Boston case, which was not plausible, that the courts would have a role here.
Okay, and
under
would that be
some statute.
certiorari review? Or would that be under, well, you're saying then that, yes, there is certiorari review, but it's an extraordinary high standard, and it's limited in scope to certain types of claims?
No, Your Honor, I'm thinking specifically of it could be an allegation under the state ethics statute. It could be an allegation under the open meeting law. I know there's one here, but we don't think it survives. It could be an allegation under the Constitution. It could be an allegation under some other independent source of law, like we saw in some of the federal cases that I mentioned. In fact, it could also be an allegation under the Gaming Act, because we defeated on the merits in Superior Court a number of arguments regarding how the commission had, mistakenly made various decisions through the Region A licensing.
What was the legal, in those cases in which you defeated on the merits, what was the legal framework in which they were raised? Was it
The legal framework was
certiorari,
this-
or what, declaratory judgment? What was it? Mr. Leonetti says declaratory judgment.
Yeah, that sounds right to me. We don't agree on very much, but I think that it was one of those. Yes, Boston brought declaratory judgment actions seeking a determination that it was the host community to the Wynn facility, and that the commission had wrongly designated Boston as a surrounding community. We defended those claims on the merits and prevailed.
And
there
did you not get declaratory relief yourself?
No, we did not make a claim. It was
There was no declaratory judgment entered?
entered. The case was dismissed. That's correct, Your Honor. So,
Is that how, in answer to Chief Justice Gans, is that how, assuming adequate allegations, in your view, is that how somebody would raise it? Not by certiorari, but by that?
yes, that is correct, Your Honor. We started out, I know Your Honor wanted to hear something more about the certiorari claim, and I would like to take just a minute on that. Section 17G, there's been a tremendous amount of focus on what I've referred to as the no further review provision of Section 17G, which is the very last part of it. But there's another section of 17G that we think has equal force, equally important force, and that it's fatal to Mohegan's cert claim, which is the provision that says applicants have no legal right to a gaming license. And this court in the Abdow case underlined that provision and said it means what it says. Justice Souter in the Caesars case, citing Section 17G, said what it says. That's the provision that led Justice Souter to say an applicant for a gaming license has no legal status more.
You know, I appreciate that, but the statute sets out a very detailed and complicated application process, and I'm not suggesting that that gives a property right, but it seems to me, is there not an argument that an applicant who cannot have, pursue gaming without a license and has a right to apply, and the government is regulating who can get it, is there not some kind of right that the governmental process be one that is at a fundamental core a fair one? I mean, I guess I'm thinking about arguments that are sometimes made in cases, let's say, against conservation commissions, that the process is completely unfair. And it seems to me, doesn't a citizen who has to get a license in order to pursue something have some kind of right to a fairness in that process?
Well, two things, Your Honor. First of all, the statute says not, that there is no right to a license itself. And if there is no right at all to the thing that you are applying for, we read both Abdow and Caesars to say there's really no right in the process that ends in that result. Now, I'd very quickly add, though, the point that I've been trying to make is that there are other legal constraints that bind the commission to do the process fairly in a non-discriminatory way, and I'm talking about the Constitution, the ethics statute, the open meeting law, the Public Records Act, and all of those are constraints on the commission here to act fairly and properly, and there is a role for this court to step in if those provisions are implicated in a plausible way in a complaint that's
Could any of
properly
them
brought.
result in the overturning of the grant of the license that was made?
Absolutely, Your Honor. I hate to keep referencing the Boston case, but it's clear in my mind. In that case, count 10 of the complaint was a declaration that the Region A license be annulled because of the serial violations of the Gaming Act. And again, the judge found that the allegations were spurious, but that was the request for relief. I think both the conflict of interest law and the open meeting law have provisions that would empower a court to invalidate the public action taken as a result of the violation.
17G says what it says. Now, the question I think that we're trying to get at, though, is it unconstitutional because it doesn't provide for judicial review? So the legislation eliminates judicial review. Just like Congress, they can't have a legislative veto. You got the charter case, they can't have a legislative veto. Can this statute constitutionally eliminate judicial review?
Yes, it can. And this is the non-delegation issue, that the non-delegation claim that all the plaintiffs have raised. Really, two things I want to say about that. First of all, we have cited the Landers case in our brief. This is the brief in 12111. It's a state racing case decided in 1951, where there was a non-delegation challenge brought against the legislation establishing the State Racing Commission. Very similar to here, the state racing license, a very comprehensive statute, like the Gaming Act. The court rejected the non-delegation challenge. It did so based on the comprehensive legislative framework defining the licensing process. In that case, Chapter 128A, the statute at issue in that case, there was no specific judicial review for an applicant denied a license. And the court noted, though, there was judicial review for license holders whose licenses had been revoked, and for the court that was good enough. So in a sense, the court has already been here once in the Landers case in 1951. Fast forwarding to today, in 1984, there's the Chelmsford Trailer Park case that sets forth this three-part test for violation of non-delegation doctrine. That test has been repeated at least 4 times by this court. In not a single articulation of that test has the court said judicial review is a sine qua non. It doesn't do that. I think an opinion that is very important in this analysis is Justice Liakos's opinion in the risk management case decided, I believe, in 1990, where he says, look, there's 3 elements to the test here. And we would permit a statute, save a statute under a non-delegation challenge, even if it was, an extremely general grant of legislative powers, if in that case there was judicial review. And frankly, we think Landers stands for the other side of the coin there, that the court would also permit a statute to survive a non-delegation challenge if there was an exceedingly detailed outline of statutory provisions and constraints on the administrative agency, even when there was no judicial review. Here, especially so, because of the other safeguards in place that we've identified. This court has never held that judicial review is a sine qua non to save a statute under a non-delegation challenge. We don't think this is the case to do it here, given how comprehensive this statute is with respect to what the legislature envisioned the Gaming Commission should do.
But
when
as it relates
authorized
to that
license.
three-part test, Mohegan Sun's position is that the legislation does not provide safeguards to prevent abuses of discretion by the board.
That's right, and we believe that it does. We understand no one takes serious issue with the first two elements of the test. It's really the safeguards issue.
Right.
And we think there's abundant safeguards here. You've got very diffuse political power appointing the commissioners. You've got regular reporting to the legislature so that it could step in if need be. You've got the ultimate political solution, which is the legislature just saying, you know what, we've decided we don't want gaming. You've got the initiative and referendum petitions there, which are safeguards. And here, as I've pointed out, there are judicial safeguards. And these aren't just theoretical. If the Gaming Commission does something crazy, like decides it's not going to grant licenses to members of a minority group, these are safeguards we've already seen in play and litigated in the Boston case. They are there, and there are other statutes that are in play. We think this case is...
Just out of interest, in defending against the Boston case, was it your position that the judge never should have gotten to the merits at all? I would assume that it was.
No, Your Honor. It was with respect to some of the claims, but we filed a 12b6 motion on the claims for violations of the conflict of interest law. And we filed a 12b6 motion, if I'm not mistaken, on the surrounding community decision. And we filed a 12b6 motion on the failure, Boston's alleged failure to be designated a host community as well. So we dealt with many of those claims on the merits, and the judge dealt with them on the merits and de novo.
Okay, I'm not familiar with the details of that case, but is it your position that somebody in Mohegan's position could be able to bring a claim under 268A, Section 9A, and seek rescission for violation of the conflict of interest law?
They could, much as Boston tried, but they did not.
They could be, and they would have standing to do so? I mean, clearly, of course, they can file an action.
Yes. Yeah.
My question is not, can they go to the court and claim it? My court is if my question is, if they were to do so, apart from the merits of it, would you say that they have no standing to do that?
No.
So they could do that?
No, we would say they had no standing.
Okay, so then what's the, who can?
Well, with respect...
Who can? I guess it's a private cause of action.
Yeah. With respect, there
Is there a private cause of action under Section 9A?
For anyone to bring an
conflict of
ethics
interest.
complaint?
No, could they bring it? You say no standing. Is that what you said?
We're talking about the ethics statute now,
Yes.
Chapter 268A.
Yes.
And we acknowledge Boston had standing in that case, so yes.
They would have standing?
Yeah.
Okay.
Oh, so they would have standing.
I believe they would, but I don't want to concede that without reading the statute carefully and the authority cited under it.
All right, but you're not saying sort of off the top of your head, no, they never would.
No, but this raises an issue that I think is worth mention with respect to many claims here. We have argued that a number of the plaintiffs simply don't have standing to bring claims. Now, there might be claims that if the commission committed, different types of wrongdoing, other parties might have standing to bring those claims. But Mohegan has not brought a Chapter 268A claim here, unlike the city of Boston.
Okay, thank you.
Thank you, Your Honor.